Live from our studios in Kingstown, St. Vincent and the Grenadines. It's your favorite Thursday night show, Up Late with Sehon Marshall. Now, ladies and gentlemen, let's welcome the host of tonight's show, Sehon Marshall.
I'm going to start sharing, and I'm going to ask those of you that can share the program, you can share this live feed coming on YouTube on your WhatsApp status, you can share the live feed on your Facebook page, wherever, so that other individuals can join in and be a part of tonight's program as well. So just give me a few minutes, and as I always, as you all program, I'm doing that now, and so just a few more clicks, and I will be there. Whenever you help me out, I will do have somebody up there, right? Um, so let's do this now. We are almost there. Just a few more clicks, and I'll be there. Just a few more clicks, and I will be there. One more, just one more. Wait a sec. Something happened there. I'm not sure what is happening. One, two, one, and we are on go. There's one more to that. There's one more to that. This one. There. And I'm almost done. Let's post this, and I am done. All right. All right. So we are here and we are live. Now, just a few things. Let me thank you again. Every week I have to thank you for helping the growth of this program. Like I said last week, we now over 1,500 subscribers to our YouTube channel. This has grown from just over 900 subscribers in January. So there's a steady growth as more and more people are attracted to this program. So, chance you get. Those individuals who are supporting our program financially, like different ways, whether it's subscription or direct financial assistance, thank you so much. Your assistance helps this program to continue to be on the air. All right, listen, it's invaluable, and I cannot tell you how much I appreciate what you've been doing. And those individuals who meet in the street every single day and just simply say to me, "Present, please." Listen, it brings a sort of joy and warmth to my heart, and I appreciate that so much. Keep watching, and I hope that these programs are adding value to this course. All right? Now, straight into tonight's program. Recently, there was an announcement that was precipitated by the make it public of the order paper for the sitting of the House of Assembly next Tuesday. And on that order paper was something that I found to be quite surprising. It was revealed that the New Democratic Party administration intends to make some amendments to the laws of citizens and revenues that most people question, that I have come in contact with, the timing and the reason for those amendments. It was revealed that the NDP intends to change the law. Where am I? Oh, it's in the, that's true. It's behind there, yes. you. And make sure that we have the correct mindset in yes, yes, yes. All right, let's make sure we have wireless mic. Make sure we have that. My apologies.
Filter.
Did you have wireless there? Mic setting. Just make sure that the receiver is on, please. Just give me a few seconds. Make sure the receiver that's probably is on. Just make sure it's on. Make it on, and then once it lights up, then we should have some current. So my apologies. Yes, there's an echo. We tried to work that out. We worked that out. We worked it out. That was my error there. Once you close that, when you run over again, you should see wires. And you should be good to go. You good to go?
Um, so we got the news that the NDP intends to change the law to what according to them is to streamline and clarify certain aspects of the existing law, the Representation of the People's Act, that is read in conjunction with the Constitution. And it deals with the eligibility of individuals to be nominated and elected in Parliament. Now, you are all aware of the challenge of the ULP, by the ULP, of the election of Fitzgerald Bramble and the Prime Minister Godwin Friday. And the idea is, the challenge is that because both of these individuals have foreign passports, specifically passports from the Federation of Canada, which is foreign to St. Vincent and the Grenadines, that our constitutional law makes it makes them ineligible to be nominated, and therefore their elections were null and void. That challenge is in the court, and there's mixed opinion as to what the outcome might be, and you expect that type of discussion. But what the NDP has done by changing the law, in my view, is to try and affect the outcome of the case, in my view, try and affect the outcome of the case by changing certain definitions which the court is allowed or should be allowed to answer. With me this evening is popular radio commentator, uh, lawyer, former politician, and former Speaker of the House of Assembly, Jomo Thomas. Let's welcome Jomo to our plate tonight. Jomo, good night, and welcome to our plate with Sehon Marshall.
Good night, sir. How are you?
I am well. How are you?
Not bad at all.
You were listening to my introduction.
I didn't
Uh,
hear any of it.
you didn't hear of it. Oh, my
No,
apologies.
not a single word.
I'm not sure why. Okay, so I was making the point that the House is meeting next week, Tuesday, and the government is proposing some amendments to the Representative of the People's Act, uh, a specific section that is to be read in conjunction with the Constitution. Now, Jomo, you and I have had discussions back and forth about the pending matter, the challenge in the court regarding the election of Fitzgerald Bramble and our Prime Minister, Dr. Friday. And you are on record as saying that you believe the case has merit. Um, After the management hearing, the Prime Minister, Dr. Friday, came out and said it was frivolous, it was a waste of time, and that he was a busy man. Uh, do you still, first of all, Jomo, hold that the case, the substantive matter, as brought before the court, is a case of merit, or do you know, have you since changed your mind to share the belief of Dr. Friday that it's frivolous and vexatious?
No, no, no. I mean, if you read, I commented ever since the issues that were listed on the order paper came to the public. I have commented and said that, well, for one, I have said that I have been saying for years that Dr. Friday and Fitzgerald Bramble have a case to answer. And I am on record of saying that I thought that if the matter had gone to court, they would lose. I probably said that 7, 8 years ago. When Dr. Friday, Prime Minister Friday, made the comment that the case was a frivolous one and was taking him away from his pressing task, I said, look, these cases are not frivolous cases, but based on my understanding of the law now, I think that they have a likelihood of success. That
And by they, you mean the respondents, Dr. Friday and Fitzgerald Bramble?
yes, indeed, that they have a likelihood of success. So I don't believe that there's anything frivolous or vexatious in the matters which were brought to the court by Luke Brown and this gentleman named Carlos Williams. But I have since come to the considered view that once the matters are ventilated properly, that they would prevail.
Okay. Now, at the heart of the matter is the question whether or not Canada is a foreign power. What is your view on that question?
Well, I think the issue of whether Canada is a foreign, I don't think that there can be, in the logical definition of a foreign power, I don't think that there's any question that Canada is a sovereign, independent state, distinct and separate from St. Vincent and the Grenadines. And consequently, we have to get a visa, or people have to get a visa to go into Canada. Canada can restrict our entry and so on and so forth, as is the case with the United Kingdom, out of which the Commonwealth arose. However, I think that there is some uniqueness about our Constitution which may cause a court to conclude that in understanding what the Constitution says about persons who are Commonwealth citizens, the court may well rule that Canada, as it relates to the definition of our Constitution, is not to be construed as a foreign power, for which we are taking it. So when if somebody by their own act take swear allegiance, that based on the particular wording in our Constitution, it may not be a prohibition, it may not be a hindrance on them contesting and participating or being eligible for the highest office of the land.
And your view of this is based on our membership in the Commonwealth of Nations.
Well, no. Beyond that, I think our Constitution talks about who can be elected to the Parliament of St. Vincent and the Grenadines. It doesn't say you have to be a citizen of St. Vincent and the Grenadines to be eligible. It says that someone who's a Commonwealth citizen can become eligible once they have the requisite resident limits. So if they're here for a particular amount of time, as a Commonwealth citizen, they can be eligible to contest, to be nominated for, to be elected to Parliament or even the highest office of the land. That's my read of what the Constitution says.
I want to read to you, Jomo, a section from the Canadian Parliament, and this has to do with the qualification or disqualification of a senator. Let me ask my director to put it up so I can read that for you.
Yes.
It says, I'm waiting on it to go up there. Hold a second, let me get that. I have it here. Hold one second. It's section 31. Because I'm a member of the Canadian. Where are we now? Section 31. Right. It says disqualification of senators. And Section 31.2 says if it takes, well, the place of a senator shall become vacant in any of the following cases. If he takes an oath or make a declaration.
You're reading from what? The Canadian Constitution?
That's correct, yes. Section 31.2 says if he takes an oath or makes a declaration or acknowledgement of allegiance, obedience, or adherence to a foreign power, or does any act whereby he becomes a citizen, a subject or citizen, or entitled to the rights or privileges of a subject or citizen of a foreign power. So we have a similar wording um, in the Canadian Constitution that relates to one's disqualification from being a senator. Now, I was looking at the electoral laws, and I didn't see anything specific to who can vote, whether naturalized citizens and Commonwealth citizens and so on could vote. I know, for example, in the UK, I went to the UK, I spent a year, but within 6 months, I got letters to be on the voters list, and I'm currently on the voters list in the UK. I could have voted. I am not sure, and this happened because I'm a member of the Commonwealth. I'm not sure if that allows me to become the Prime Minister of the UK or to become a member of the Parliament of the UK. But I just found it interesting that a similar wording exists within the Constitution of Canada, the country in question, for this particular court matter, and it speaks to the disqualification based on the pledging of allegiance to and the submission and rights and privileges as a citizen of a foreign power.
Right. So your
But
question is?
I'm just saying. I found it interesting. I find it interesting that there's a similar provision, and I don't know that there's a
But
discussion.
I think, you see, for example, see, and I remember some time ago I heard that a Canadian international law expert is being called in. I am not so sure why a Canadian international law expert is being called in. The document that is being interpreted is the Vincentian Constitution.
Right.
So it matters not what the Canadians say. It is fundamental what our Constitution says. And our Constitution says a number of important things about the common, who can become,
Yes.
who can become, and it speaks specifically
To Commonwealth citizens.
of a Commonwealth citizen. There's a particular section I want you to, I think it's section 94 of the Constitution. If you give me a chance here. Is it 94?
I believe it's either 94 or 95, yes.
Yeah, it says, requiring association. 95, for example,
95,
says,
yes.
in this chapter, alien means a person who is not a Commonwealth citizen.
Yes.
A British protected person or a citizen
of the Republic of Ireland.
Right? British protected person means a person who is a British protected person for the purpose of the British Nationality Act of 1948.
1948, yes.
And it says, a person born abroad. So those are some of the things that I have looked at. If it says an alien means a person who is not a Commonwealth person,
Yes.
then this is why I say that I think that the gentlemen have a case to answer, but I think that they will prevail because of the peculiarity of our Constitution. For example, I saw our former Prime Minister and others, my good legal colleague, Luke Brown and others, have made heavy weather of the St. Kitts case, the Denzel Douglas case. The difference, however, with the St. Kitts Constitution, our Constitution, is that the St. Kitts Constitution specifically talks about eligibility being somebody who is a citizen
Of St. Kitts.
of St. Kitts. That's not the case in our Constitution. Unless you can point me to something in our Constitution which I have missed. But that is not the case in our Constitution. So those are the reasons upon which I have moved away. You know, I also saw where different persons who hold a different view than me, they cite the case Darrell Vaz, Abraham Dadoub versus Darrell Vaz. And I think that paragraph 35 in that case, and I hear people talk about Vaz and the fact that Vaz was disallowed because he was an American citizen. But the persons who are being challenged are not American citizens, they are Canadian citizens. And here's what the court says, the Jamaican Court of Appeal. It says, the framers of the Constitution clearly intended that Jamaicans who by their own act sought or received non-Commonwealth citizenship, or having not so sought it, nevertheless voluntarily acknowledge allegiance to such countries, should not sit in the House of Representatives. It does not matter that they were born in Jamaica. It is a notorious fact that over the years, many Jamaicans have acquired foreign citizenship, and many others are constantly in the process of seeking such status. If they choose a distant, and this is instructive, if they choose a distant, autocratic, unfriendly Commonwealth country for citizenship status, they can still serve in the House of Representatives. If, however, they choose to acquire such status in the United States, as Vaz did, they are disqualified. That may seem an oddity, given the fact that many Jamaicans seek United States citizenship and are more likely to be accommodated in that country compared with the level of accommodation they would receive in many Commonwealth countries. However, that is our Constitution. And I think that's a powerful argument. And the Jamaican Constitution on that is quite similar in many regards to our Constitution. So, I mean, like I said, I am not a judge. I have no aspiration to be a judge. But I've read a number of these cases that are bandied about. And I think that there are some differences between because in the end, we are going to interpret our Constitution. It is not any other Constitution that we are going to interpret.
Yes.
And that's where I think that the gentlemen who are being challenged, it's an important case. It would settle fundamental issues. But that's why I believe that based on my read and what I have gleaned from talking to other people, that they would prevail. A number of other another argument is that, look, you have to read it is clear that we have to read sections 25 and 26 together.
Yes.
But a number
because
of
one
people,
is subordinate to the other.
yes, or so it is said. But you see, Constitution.
Well, I mean, that's what it says in the contract. It says subject to this one. So if you're subject to, then you're subordinate to.
Constitutions, and you are a lawyer, so you would know that there's a purposive reading to constitutions. In other words, you get the broadest interpretation of constitutions, and it would be contradictory, and I believe this is the issue that would be decided in the case. That if the argument as is presented by the persons who are opposed to Dr. Friday and Mr. Bramble, it seems that the contradiction gives something in the right hand and take it away in the left. And I am not so sure that is the way in which the Constitution ought to be read. The Constitution is a very purposive document. At least the modern view is that you have to have a purposive reading and a purposive understanding of constitutions, which would give the broadest amount of rights. A constitution is not intended to limit the rights. So that is just another point. But that is what I just presented is a rather arcane legal argument that many people, ordinary people who are not in tune with constitutional arguments and decisions it may go over their head, or they may think, well, oh, I'm not even sure what he's talking about. But
Right.
it is something that is going to loom large in the case.
I'm glad you mentioned it, because I don't want us to get too bogged down with the legal aspect of it, because I want this to be something that regular people could follow. But before we move on to something else, Jomo, you said
But just before we go on though, what you thought of that paragraph 35 in the Dadoub versus Vaz case? Because it seems to me that Jamaican Court of Appeal is making a centrally important point, or do we just disregard that and say that it's Jamaica and not St. Vincent, when in fact the Jamaican Constitution is very much like the Vincentian Constitution?
and you're right. So I suspect that the respondents would use that as the pillar of theirs, in the same way that the applicants seem to be using the St. Kitts constitution as a central pillar of their argument. And I recognize exactly what the appeal court in Jamaica said. But you made the issue of citizenship, and you said St. Kitts constitution speaks to citizenship.
Citizens
St. Kitts only.
as a prerequisite
Yes,
for
yes,
eligibility.
yes. But for us,
Vincentian citizenship as a prerequisite for
right.
eligibility.
So, but my question to you, Jomo, is while you may, while our constitution may not, if I were to use your argument, use Vincentian citizenship as a qualifier, merely residency, it does, however, by its broad reading, speak to citizenship of somewhere else by your own free will as a disqualifier.
Yeah, but it says fundamentally that it seems to say, and the British, and I have made this argument many, many years ago, our constitution is essentially a British constitution.
Mm-hmm.
It is intended to give rights to the British that it does not even give Vincentians. Yeah, the British can come at any time.
Right.
Vincentians, for example, if you go to live in the United States, you are a goner in terms of high elective office in St. Vincent and the Grenadines. So that's an issue there that needs.
Very interesting.
Yeah.
So we move to the crux of.
But just before we go, Sian,
Yes.
could we take a 1 minute break?
Sure, absolutely.
Yeah,
Let's
please.
go on with break. All right. So we are chatting with Jomo Thomas, lawyer and social commentator, and we're discussing the proposed amendment to the Representation of the People's Act, the section that is to be read in conjunction with the Constitution that deals with the validity of electors to our parliament. And we were just giving a background as to the matter that is before the court, and we were looking at the constitutional provisions that are the provisions in question. Now, when Jomo comes back, we'll get into the discussion of the sections that are being amended, and we'd look at the reasoning behind the amendment, because remember, there is a live case in the court, and the sections in question are sections, the Representation of the People's Act, Section 35. And the particular ones, excuse me, has to do with the disqualification of people who, by their own act, the Section 35(1)(a), is by virtue of his own act under any acknowledgement of allegiance, obedience, or adherence to a foreign power or state. And what is being what the court is being asked to adjudicate on, and this is where I think the amendment run into hot water, because the court is being asked to adjudicate on that same thing that Jim and I were discussing. What constitutes a foreign power or state, and whether or not having the Canadian passport rises to having allegiance, obedience, and adherence to a foreign power or state. That is what is before the court. But before the matter is even heard, the New Democratic Party administration has decided to amend it and give a meaning to the same matter that is being questioned, that is being brought up, and the court is being asked to interpret. And that is the issue that many individuals are having, including myself, because in my view, they are seeking to address or dictate the outcome of the case even before it's heard. And that is the challenge that many individuals are having, right? So we're going to get into a bit of that when Jomo comes back, because, well, my director didn't put you on the screen, so I don't know why. All right, so Jomo, so we hear that the government, with a 14-1, almost a supermajority in the parliament, has decided to amend Section 35 to address the matter. Now, I want to play for you
Section 35 of what?
of the RPA, the Representative
Right.
of the People's Act, right?
Right.
Based on statements from the Deputy Speaker of the House, Jamali John, to bring clarity or reduce the ambiguity. I want to play for you a clip, an interaction with Senator John and the host of Hot 97 when
Yes.
asked about the reasoning behind this amendment.
And just back to the point, so it would not be fair to say that this is a self-serving law to try and get around the current predicament. This is for future, just to clarify what you mean by foreign power.
It's not only about this case, right? As I said, and
is it about this case at all?
No, I would not say so.
Right.
Right, and I don't want to say too much because I still have to speak to this in Parliament when I go on Tuesday.
Right.
But one of the points that I will make is that Parliament has a specific role and function, and so does the court. The court is not there to make laws. The court is not there to change laws or to repeal laws that rest with the Parliament. The court is there to interpret the laws that Parliament passes.
Right.
And so if the role and function of the Parliament is to make, change, and repeal laws, then we should not say, oh, well, let the judges do it. No. The Parliament is the lawmaking body of St. Vincent and Grenadines,
right.
And the Parliament will continue to make laws, amend laws, repeal laws as they see fit, and give direction to the policy positions that we think best.
Right.
Right? We don't leave judges to make those determinations for us.
Yeah, makes sense.
Your thoughts, Jomo? He says that there's ambiguity.
I heard
Right.
him.
Your thoughts?
Jamali is my brother.
He's mine too. He's mine twice because we are church brothers too.
Jamali is my friend, but I disagree with him. And I disagree with him fundamentally on that question. Parliament is not there to change the Constitution.
Or even
Parliaments, I know we have the supremacy of Parliament, yes, and so on. That's the kind of setup that we have. But there are a number of things in my mind that's wrong with this proposed change. Off the bat, it demonstrates a tremendous lack of confidence in the government's view as articulated by the Prime Minister, that the case is a frivolous case. Because if the case is a frivolous case, then why move to change the Constitution? So, two things loom large. Is either you're looking for security or you're looking for insurance. That boy, just in case some judge have a view which is different than ours, we want to put this in there. There's that. But even more than that is the rank opportunism that one sees with the attempt to pass this act. If the government was serious, or if the government is serious about constitutional legislative policy reform, they could have said, because section 26, 25 and 26 are not entrenched clauses, meaning section 25 and 26 of the Constitution are not entrenched clauses, meaning that you would need a 2/3 majority, and even if it needed a 2/3 majority, they have a supermajority, they have 14-1. It's a 14-1 parliament, and that you don't need a referendum in order to change. So if they were serious about real reform, real constitutional reform, in my mind, what they would have done, or could have done, or propose, is to say we are going to change the law to ensure that from now on, any Vincentian, whether they are in Zimbabwe or Canada or the United States or Germany or Australia or Norway or Sweden or South Africa or Australia, any Vincentian any person born in St. Vincent is eligible for election and or nomination to high office. But to circumscribe it in the ways in which this is circumscribed is to do two things: is to remain locked in a British colonial mindset about this whole Commonwealth country, and to say we're just going to tweak this, but the tweaking is fundamentally intended. I mean, my friend Jamali said this is not about now, this is not about the case, but it's palpable that this is about the case, and it's to put some guardrails in the event that Justice Tom, hearing all of the arguments, decide that, look, I think that the argument of the petitioners is more persuasive, because as I understand it, the amendments really makes the case moot.
Yes. Because it addresses the question.
It addresses
the court is being asked to answer.
The fundamental question that the court is being asked to answer. And there are three branches of governments. The executive carries out the laws, the legislative branch make the laws, and the judiciary is uniquely placed to interpret the laws. Here you had a situation where some parliamentarians, two parliamentarians, Prime Minister Friday and Foreign Minister Bramble, are citizens. There are clear questions there. Did this swear to a foreign power? It is now for the court to resolve that definitively, and if the court rules against them, they can appeal to the Court of Appeal and see what the Court of Appeal would do. Because remember, in the Denzel Douglas case, Denzel Douglas prevailed at first instance, and the Court of Appeal overturned now Court of Appeal Justice Trevor Ward. But Trevor Ward was the sitting judge in St. Kitts at the time when that matter came up, and ruled that in his deliberate judgment, he did not think that the acceptance of the diplomatic passport from Dominica was violative of the St. Kitts Constitution. The Court of Appeal said, no, 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 I think you're wrong, and reversed Justice Trevor Ward. So, but I think at its highest, what this is all about is a demonstration of the jitteriness, the lack of confidence that the governing party has in its case.
It's interesting, Jomo, because I'm listening to Jamali, and I want you to talk a little bit about this as well. Because it seems to me that he has, although he said in the interaction that the role of the court is to interpret the laws, it seems to me that the cabinet of St. Vincent and the Grenadines has taken that role away from the court in imposing its interpretation of the question that the court is supposed to answer. As you said, essentially nullifying the case, because now the court no longer has the role of interpreting what that section of the Constitution and of the RPA means.
Right. And it's going to be interesting to see how Justice Storm rules on this point, because Justice Storm is a very, very experienced judge. It must be remembered that Justice Storm was here for like about 12 years. Then she was elevated to the Court of Appeal, where she spent about 10 years. And now she's back here as an acting judge. So she has a tremendous amount of judicial experience, and it would be interesting to see how she rules.
Let's talk about Jomo, because we haven't delved into it. Let's talk about the retroactive nature of this amendment as well. They're not, like you said. My thing was, if you allow the court to interpret it, if you're saying this is about the interpretation, there's a live matter before the court, allow the court to rule, and if the court rules against you, then you can amend the laws to bring it in line with what the court says, because that's your role to amend. Or, as he was trying to make the point about having nothing to do with the case, you may well find, as you said, if they prevail, then it would have made the amendments pointless, because the court rules in their favor. But they're changing the law, and they're not only changing it for now, from now going forward, they are making it retroactive to the beginning of the Constitution. Explain how that works, and whether or not that is something that could actually stand against a judicial review.
Well, I can see what they want to do, because this, if we can call it, this conundrum in the law, this lacuna in the law, was there ever since the Constitution was promulgated in 1979. So if you're going to tinker, you want to go all the way back. But the retroactive nature is equally troubling to me, because when you're going to do constitutional changes, you want to appear to be not reactive, but proactive. You want to be projecting forward rather than trying to do a stopgap measure. Because it is said that this act is intended to bring clarity. But it seems to me that they, by their act, by their proposal, is saying, we are going to bring clarity by saying what this means. But because of where we are, it seems, I would argue that it is the court who should interpret it. And if the court interprets it, and the court says it is not what Mr. Bramble and Dr. Friday and A.G. Mitchell thinks, after that case, the parliament could say, you know what? This is what we want. In fact, that's the way it's done in the United States and other democracies, where the court may say a particular thing, right? Make a particular interpretation. And then the Congress in the United States may say, okay, we understand what you said, but from here on in, this is what this means. But to try to go back. And if there were no challenges and this was done, I don't think it would have been either here or there. But it is, to me, it's wrong where in the face of active litigation, you are trying to do something which essentially says that, now, what our interpretation of this is the interpretation we want the court to go with. And yeah, there's parliamentary supremacy and everything else, but I don't know if there's any precedent for that. I have engaged some of more senior constitutional colleagues, and I'm sure I'll have a better understanding by the time we go to Parliament on Tuesday, because, like I said, they know much more than I do. But it does not fit well. It does not sit well with me.
If I can go back a little bit, Jomo, and I'm going to remind you of something. The first time I came on your program, it was to discuss the proposed constitutional amendment back in 2009, and I was joined by Richard Byron Cox, and that proposed constitution had an amendment that dealt with, or a section that dealt with dual citizenship. That is now coming to the fore. You have former Prime Minister Dr. Gonzalez suggesting that, listen, this was something that went to the people, that they're going to allow people with dual citizenship to run, and they voted no. As a matter of fact, the NDP campaigned and told them to vote no. And now you're trying to bring it, and you're bringing it not as wide, like you said, as it should be in terms of allowing all dual citizens, but just specific to the Commonwealth. Do you see any comparison there? What are your thoughts on that comparison, that reference to the proposed approval sections of the Constitution?
Well, I mean, Dr. Gonzalez has made that argument many times. I've seen prominent columnist Renard Rose make it as well. But I don't think it is a proper argument, because so many things, we were doing constitutional reform wholesale, in which a whole host of things
Right.
were being proposed.
Right.
And the fact that the constitution, the proposed amended constitution was voted down is not an indication, or there's no clear indication that people did not want to see a situation where someone with dual citizenship could contest. So I don't give a lot of credence to that argument. But I was one of the persons who supported the proposed constitution. I thought it was a clear advance on this colonial document that we have, and it was unfortunate that it was voted down.
But Jomo, interestingly, and just one more thing on that. Interestingly, I'm sure you heard it, the opposition made a big deal over that specific provision about dual citizenship, trying to tie it to Camilo's citizenship to the U.S., saying that this was about Camilo, this was Ralph trying to allow get Camilo to run, and so on and so forth. I heard those comments back then. I heard those comments pushed forward by the NDP. But now, this is a clear indication of an amendment, a proposal being done just for two specific people.
But you see, that's the problem with our politics. You see, too much of our developmental challenges are constrained by political baggage. So much of what we do is not done for the advancement of St. Vincent and the Grenadines. It is done in a way, or it is packaged in a way, either by one side or the other, to score political points. I'll give you an example. You may recall that after the 2015 elections, there were challenges to the North Leeward, not the North Leeward, the Central Leeward,
Central Leeward, yes,
and North Windward.
yes.
And PM Gonzalez then, I'll read something that he said. I'll read something that I'll read something that he said, just to give you a feel, right, of how these things are played out.
I know he spoke about elections not being won in the court.
Yeah, he says following and I'm giving you a part of in my column this week. I said
Right.
following the 2015 elections, petitions challenging Louis Strake and Montgomery Daniel. Gonzalez said, the courthouse does not determine who represent us. I want to emphasize that. People who represent us are those whom people vote for in an election. And there will be other elections in St. Vincent and the Grenadines in which real flesh and blood people who are entitled under the law and constitution to vote will vote. That is our system. Judges do not decide who our representatives are. You know, so when we think about some of these things, too much of it is wrapped up in
But
partisan
surely, Jomo, context is important.
Yes.
I think
And
both
what's the
situations.
context you want to bring to your audience?
No, so I'm saying both situations are markedly different. You have, in the case of Central Leeward and North Windward, they were trying or they were suggesting irregularities that would amount to invalidating the elections. We're talking a situation where Ben Exeter lost in all but two polling stations, and those two polling stations he won by a little drop, 2-6 or something like that. And there were no irregularities, but this was a situation where people were trying to abuse the court system to overturn the elections, as opposed to now the government is saying, and Jomo, this was something that was said even before the elections. Guys, you have dual citizenship. You are not eligible to be nominated. If you go and you're nominated, we will challenge the result.
Right.
I think the context is different.
I hear you.
Because these are people who should not have been nominated.
I think that's a reasonable argument that is made. But I was showing you how politicians frame and shape arguments to speak to. So then you said, well, the court shouldn't be doing this, and now you're saying, yeah, let the court decide.
I hear that. Now, I finally, Jim, I wouldn't keep you much longer, but I want us to talk about the outcome. You are adamant that even if the guys were to not prevail, the respondents were to lose the case, that there will be by-elections. There is a strong suggestion from the applicants
Yeah.
that no by-election, because based on the law, if they were not validly
What the law says.
well, and I think this is case law. I'm not. I think they refer to case law because I can't quote the law. If it is written, I don't have it, or I don't know it off the top of my head. So if you can, but the suggestion is that because they were not validly elected, that the election is invalid. It didn't happen.
Right.
And so, because it
But
didn't happen, it's like you, Jomo. You the best sprinter, and you line up for the 200
disqualified.
meter, and you disqualified because you took
Yeah.
drugs. That's it. Your record goes, your medal goes, and the person who comes second, even if you beat them by 3 seconds, is still the champion. So that is the reading I'm hearing from Dr. Gonzalez. I heard Sir Louis
Right. I have heard
speak to
him say
that.
that.
Sir Louis said that in
Let's
1994, a similar challenge was being raised by then Attorney General Parnell Campbell because they thought that Sir Louis had not renounced his citizenship, and Parnell was seeking to get Hobby just put into the seat and have the seat vacated because he didn't
Right.
realize that Louis had renounced his citizenship. So it's based on those, I believe, that this idea is coming from.
Yeah, no. I understand where it's coming from, but I think that we have to ground what we are saying in the Constitution. So
Right.
if you want to go with me
Right.
to Section 49 of the Constitution,
Yes.
elections to the House of Assembly,
Right.
it says where the seat of a member of the House falls vacant. I'm reading here 49:4.
49-4. Uh-huh.
You got it?
Yes.
Where the seat of a member of the House of Assembly falls vacant, otherwise than by reason of a dissolution of Parliament. If the vacant seat is that of a representative, a by-election shall be held. If the vacant seat is that of a senator, an appointment shall be made. How do we get around that constitutional provision?
So my question is, if in the case in this particular case, is it that the seat will be vacant, considered to be vacant, vacated, or is it that the seat was never filled? Are the wrong persons in the seat?
Well, that's a creative argument to make. It seems as though you're well on your way as a lawyer. It's a creative argument to make, but the question is whether, because if I'm on the other side, I am arguing that there was an election and there's now a vacancy, because there can be no denial that there was an election.
Yes.
There can be no denial that there was an election. So
And the seat was not filled properly.
well, that's what I'm saying to you. I hear that argument, but my argument is that there was an election and the seat is now vacant. Therefore, we must go to what does the Constitution say? Because the Constitution is the highest law of the land. And just remember, the Section 35 of the Representation of the People's Act cannot trump the Constitution because that's subsidiary legislation.
Right.
A statutory legislation can't trump what the Constitution says. So when people say, "Well, oh, the Representation of the People's Act says so," it's like when I back in 2018 February, when I foolishly allow myself to be led down a road which says that you could amend a resolution for a vote of no confidence. And why did that happen? Then Finance Minister Camilo Gonzalez, in my mind, then made the persuasive argument, look, Mr. Speaker, the standing order says that we can amend any resolution, right?
Right.
So I said, okay, that sounds reasonable to me. And I said, after battling with Prime Minister Gonzalez and all of the others for like about 3 hours, why we should have the debate. But in fact, even then I ruled, okay, we are going to have the debate. And then they brought the amendment. And I mistakenly, I think, concluded, well, yeah, if the standing orders say that, then we must have the amendment. But the standing order is subsidiary legislation. It couldn't trump the Constitution because the Constitution is the highest law of the land. So that was my error.
Here's how I see it, Joe. Right? If I put out an advertisement, I'm looking for someone to fill a position that's XYZ and so on, and the post must have no criminal record and so on and so forth. You come and you lie about your criminal record.
Yeah.
So I hire you. I make it permanent and so on. 2 years later, things come up that way. This man has a criminal record.
You feel me?
I fire you.
Right.
Do you have any right or entitlement to tell me that you want severance and so on?
No. But your example is
I'm going somewhere.
Your example is in opposite.
I'm going somewhere.
Okay.
The point is, Jomo, the reason why you can't claim severance and all of that stuff is because you lied on your thing. You were never hired, essentially. So you have no rights or anything as an employee.
Right.
As opposed to, if you were properly hired, then I owe you all of the things that you entitled as an employee. And so,
the difference is this.
Yes, tell me.
Is that if the court rules that these men, Dr. Friday and Mr. Bramble, were ineligible, it is
were not legitimately.
Right.
I were not nominated.
It is not Dr. Friday and Bramble who is arguing to be placed back there. The matter is now for relief. It's thrown back to the Constitution. And Section 49 of the Constitution speaks to what happens when there's a vacancy.
No, but as again, my thing, as we move on from this, my thing is, the vacancy was never filled since the election.
No. I hear the point, and I'm
That was
saying
my argument.
I am
I'll make it
saying
an argument.
it is a reasonable argument.
Right.
It is an argument that evidently, if we get to that, would be made, and if the court agrees with it, then the question becomes who to follow. Do we follow the Representation of the People's Act, which is subsidiary legislation, or do we follow the commands of the Constitution? I am saying that the Constitution, the commands of the Constitution must be followed. You have a different view, and I respect that.
No, but this is my interpretation of the Constitution. I am following the Constitution.
No, where does the Constitution say that?
Well, according to you, it says when it becomes vacant. Yes, in 49, yes?
Yeah.
You read 49. It says if it becomes where a seat of the House falls vacant.
What does
And I'm
vacant
saying-
mean? What
and
is?
I'm saying
Let's do interpretation. Let's take
It
the
says-
plain.
it says-
Let's
it
hold on.
says-
Let's take the plain English interpretation of the word vacant.
Right.
What does that mean to you?
Empty.
Empty.
Right. And my
if it's-
argument is that seat fell vacant when the parliament was dissolved. It didn't fall vacant because of the case, because
No.
according
But
to the
that
ruling-
argument.
according to the ruling, you were never validly nominated. So the vacancy of the seat remains since the constitution, the parliament was dissolved in November.
So you are saying that there was no election then in East Kingston and Northern Grenadines.
There was an election.
Right, but that's the point.
And there was one candidate
Oh, there was one candidate. Okay.
who didn't fill the seat.
Okay. Well, it's and this is why, Sehon, this is why I want to be in the court on the 27th, 28th, and 29th of July to hear the arguments from very capable attorneys,
Yes.
and then wait with bated breath for Justice Storm's decision. Because essentially, it's going to resolve the issue.
Yes.
And that would, we know whichever side prevail, the other side is going to appeal. So this is going to land, it is going to be the Court of Appeal that will resolve the issue. But I think it's quite exciting.
I agree. Jomo, just before you go, and I gotta let you go. Back because I don't want to keep your plate in there.
No. I mean,
okay.
if you have something for me, if you have, I'm up late already.
Okay,
I'm up late with Sehon Marshall.
Good. Go on. Now, Jomo, we've agreed, you and I, that this law that is being, this amendment is essentially going to thwart the direction of the case.
Well, I think so. Well, it depends on how the court rules. I don't know if the court is going to agree that it does. The court could say no, for the purposes of this case, that amendment is set aside and toss it up to the Court of Appeal and hear what the court says.
An application would an application have to be made for that to happen?
For what to happen?
Because remember this.
No, the court. I am saying when this matter comes up, the court could say it is not going to. It is pronouncing without addressing the issue which the Parliament dealt with on the the 20th of April, 2026. It is not pronouncing that. It is pronouncing as on the law as it obtained at the time when nominations were made.
And so making this retroactive doesn't tie the court's hand in the way
it is for the judge. It is for the judicial officer, in my opinion, to look at the case as he or she sees it and to bring any piece of law that helps to resolve that case. Because the judge don't have to get it right. The judge simply has to do a reasoned analysis, taking what he or she thinks are the proper pieces of law that should be addressed in resolving the matter and writing a decision. Like I said, whether this amendment is brought in or not, this matter is going to be appealed.
Yes, agreed. Do you see any other avenue of challenge though for the opposition? Let's say um, if when this law passes, because there's nothing stopping it from being passed next week Tuesday with a
No,
supermajority like they have,
nothing.
right? Do you see an option of the opposition uh, applying for judicial review of this piece of legislation, especially in the circumstances?
Well, I mean, if I were on that side, it would seem to me that I would want to review the passage of that. Remember that all legislation properly passed in Parliament has the presumption, but that's all it has, the presumption of constitutionality.
Hmm.
The courts have said that presumption is a high presumption, but it is not cast in stone. So, yeah, you say if we say this is ultra virus or unlawful or illegal, and let a court pronounce on that too.
All right. There's suggestion, Jomo, that and I'm hearing it. I walked your tongue and so forth. There's suggestions that the timing, not just from a legislative standpoint because of the case, but from a social standpoint, there are suggestions that the timing of this matter couldn't be more wrong. That there are much more pressing issues in the country, and the NDP is choosing to do something that is as you put it quite self-serving. Do you agree with that?
Well, I mean, I think that they are burning critically important capital. I mean, they have a lot of political capital, but they are burning it unnecessarily for the reasons that I articulate. I think that yeah, you have a case to answer, but they will prevail.
Mm, mm,
So I don't know why they would want to bring this, because all it does is give Prime Minister Gonzalez a platform on which to bring issues to the fore which may be persuasive to independent minded thinking people. Because the fact that independent minded thinking people say enough of you in November does not mean that an argument or the act of introducing this bill will not cause them to pause. It doesn't mean that they would break fundamentally. But remember, as I said to you earlier today when we passed,
yes.
political support is like a block of ice. It doesn't even have to be in the sun to melt.
Yeah. It just smells. Yeah.
It meant it's up as a natural course of things,
Yes.
right? So I don't know. I think it's there's really no reason to burn that capital, but I am sure that they in their wisdom think that this must be done. It one person I can tell me, well, boy, I'm not so sure if we can trust the judges. And you know, there has been a lot of skepticism in St. Vincent about judges over the years, particularly under the ULP tenure. But the problem with that is that you can't love judges when they rule in your favor and hate them when they rule against you.
But isn't that what happening, Joe? I think it's manufactured skepticism because, like, if you remember, when there was an
Well,
election petition and I think it was Judge Justice Henry, Daniel come and said, "Yeah, man, you should give her all petitions." And then
that's
the
the
very
point.
next one, when it was ruled against them,
That's the point.
I think yeah, she allowed it to go through, and then when she heard it, she threw it out. ESCO was the worst thing, So I'm not sure if there is a general skepticism because you don't get that, let's say, in criminal matters and civil matters and so forth. You get it in political matters where we are
Well,
in a
that's not true.
position.
Litigants all the time are very
Well,
upset with judges.
most of lawyers, I think, most
You know, they're
yeah,
very upset.
most of lawyers,
But my position on it is that, look, you go before a judge, you argue your case the best you can. If you think the judge erred, you go to the Court of
court appeal,
Appeal.
of course, absolutely, absolutely. All right, Joe, well, let me thank you so much for sticking around tonight,
Man, yeah.
with Sehon Marshall. Listen, this was a fantastic discussion. I'm sure the individuals on the live thoroughly enjoyed it. Thanks for your insights. And like you, I'm looking forward to being in the court to hear the arguments put forward by both sides. Thanks a lot,
Maybe,
buddy. Have a good one.
maybe the court is too small.
It is definitely, we should get in park, right? We should set it up in
Well, I don't know
park,
about the park, but we should carry it in a big
in
arena.
a big arena. I think so. I think the interest, if you look just from the case management data alone, the level of interest, I went there, couldn't even get inside. They were standing room
Right,
only.
right.
So I'm sure that level of interest would remain.
Yeah, it's going to
And
remain. It's going
and,
to
and I
remain.
think we should definitely make it possible for as many people, or at least if not, allow cameras inside to stream it.
Yeah, to air it.
Yeah,
Yeah.
yeah. That is probably something that maybe should be suggested. I don't know.
I don't think Justice Thomas would allow that though. Because she wouldn't want the court to become a circus.
No, but it's something of grave public interest, and I think having
Well,
maximum
the U.S.
participation.
Supreme Court has matters of tremendous interest. They have been around for 50 years. They still don't allow cameras inside.
Wow. But there's audio though. There's audio feeds coming out of
Yeah,
the Supreme
yeah.
Court. So,
The
but
the
at
um
least,
the British Supreme Court has now allowed have been allowing people,
so maybe that is something we could look into. At least a radio feed
Yeah,
from NBC Radio or something, so that people could get a capture of it. All
yeah.
right, Jomo. Thank you, buddy.
Okay,
Have a
man.
good one.
Until we meet again, all the
Until
best.
we meet again. All the
Thanks for the
best.
invitation.
No problem, man. Anytime, anytime. All right, that was lawyer Jomo Thomas joining us here, staying up late tonight with us, and I believe really adding value to the discussion. And I really enjoyed, bouncing things off and putting my argument, because I tell you, whenever Jomo and I meet on the street, there's always a discussion. There's always something where we bounce things off, and sometimes we don't see eye to eye. But every now and again, he just give me a little pip now. Like he tell me that's a brilliant argument. Well, he didn't say brilliant. It's a good argument. You will learn to become a lawyer. So yeah, boy, yeah, that one is nice. But I talk some politics. I can't just do it so I can let Jomo go, so I can get at least 5 minutes of politics. Because one of the things that Jomo said, and it was said by Jomo in his article, one of the things that he said was that it was unwise and self-serving. And I was listening to Richard Byron Cox this morning. And as I was listening to Richard, and I think about things, I heard him making some of the same points as I'm thinking about them. And I said, boy, you see what's happening? When you have a student, because it is my student, never mind, we just tell all you, he's my student. When you have your student sitting at your feet, the student become the teacher, so now he's thinking like me. As I think them, they roll off. I kid you not. As I think them, they roll off it tongue. I say, wonderful. Wonderful. The NDP has always been a self-serving party. And we've always made the point that these guys are only interested in themselves and their friends. And they've shown time and again that they are willing to go to the parliament and use the parliament as their personal thing to pass legislation that benefits them. I remember former Prime Minister Mitchell saying to me, he was lamenting about the unfairness of the situation. This is after the Grand Breach Accord, because I mentioned to you guys, many times, that at the time when Sir James Mitchell, the former Prime Minister of this country, handed the keys over to Arnim Eustace, I was actually spending the weekend at Shrewsbury House with a group of my students, his daughter, Gabia, included. So, former Prime Minister Mitchell and I had a relationship. We spoke. We spoke regularly. As I taught his daughter, he would call me regularly and I would discuss his daughter's progress and so on and so forth. And I remember one time in discussion, he said to me that he was trying to help, what's the man name, boy? Nantan. What's his name again, boy? Nantan. One Nantan name again. Somebody watching it, give me the name of the man. Stuart. So he was trying to help Stuart Nantan. And he was making the point that Stuart died with his mother, having to spend his last money buying medication and so on for him. So while teachers and so forth were trying to get salary increases, the former Prime Minister, and that may be a good gesture for him, because Stuart was one of his senators and so on, Senator Stuart Nanton, he saw the need. He thought that Stewart had a grave enough need for him to go to the parliament as part of a package to assist Stewart Nanton. But it wasn't just Stewart Nanton, it was the wives of parliamentarians and so on and so forth, reducing the length of time you had to spend in parliament before you get gratuity and them kind of thing there. That was a bill that served the narrow interest of the few people in parliament, not the population as a whole. And the point was made again this morning by Richard, as has been made by former Prime Minister Dr. Gonzalez before, as I have made time and again, that I remember when the number of scholarships offered in this country were 2. Every year is 2. The method that 1, they carry it to 2. And it was 2. You had bright boys like Milan Mulrain and all the others and so on who came through, can't get no scholarship. But the minute Minister so-and-so picnic come out, scholarship go up to 3. Minister picnic get it. The minute Minister so-and-so picnic get, boop, scholarship go up to 4. The increase in scholarships to 4 maximum was only done at a point in time when it benefited the narrow group of individuals who served the NDP. People getting NCB scholarship for 4 years but spending 6 and 7 at UE. Because they're close to the NDP. And so this legislation that protects 2 individuals in the NDP. I mean, I listened to Jamali. There's another clip I wanted to play for Jamali. I hear this clip here. The man is telling me that the parliament is not only going to pass the law, but it's going to interpret the law too. That's not the role of the parliament. And Jamali is a lawyer, he knows better. Deputy Speaker, let's play the clip. Let's play the clip of Jamali. Second interaction on Hot 97.
Question that causes ambiguity is what exactly is a foreign power or state, right? There are some who say, well, doesn't matter. All other countries are foreign powers and states. And there are some who say, well, our constitution says countries within the Commonwealth are not foreign powers or states, right? And you would hear them talk a lot about the Denzel Douglas case out of St. Kitts, but the constitution in St. Kitts is actually very specific. It requires you to be a citizen of St. Kitts and Nevis. Our constitution is different, and that's one of the points that will eventually be trashed out in the court, because our constitution is not identical to St. Kitts. So they have lifted the interpretation out of that petition case to apply it wholesale to St. Vincent, when in fact the constitutions are not the same. Our constitution says Commonwealth citizen, right? And so we need to clarify exactly what foreign power or state actually means within our own local.
You see, here is where I disagree with Jomo. And I disagree with Jamali as well. You see, we're having 2 discussions there. He talks about the case in St. Kitts and references the fact that it speaks to being a citizen of St. Kitts. And our constitution doesn't talk about citizen. And so the quote-unquote ambiguity he's referring to doesn't address that if you want to make it specific to citizens, then simply put the amendment to say that the individual must be a citizen of St. Vincent and the Grenadines. But their interest is not in clarifying who is a citizen and who can run in St. Vincent and the Grenadines. They are interested in changing the constitution to making another country. You understand what he said? He's saying that the ambiguity is what is a foreign power state. And as Jomo said, there's absolutely no ambiguity there. Ambiguity means confusion, some uncertainty. there is absolutely no uncertainty as to whether or not Canada is a foreign power or a foreign state. All of us know it is. So there's no confusion there. There's no uncertainty there. That does need to be cleared up. But what you are doing is creating confusion by telling us that Canada is not a foreign power. What do you mean it's not a foreign power? So when somebody show up by the airport next week without a Canadian visa and so on, they could just go and say, listen, you're not, according to our law in St. Vincent and the Grenadines, you're not a foreign power. You're not a foreign state. Do you see the ridiculousness of that argument? That Canada now is not a foreign power or a foreign state. It's not an independent sovereign state to St. Vincent and the Grenadines. We and Canada are one and the same thing. So this is not about clarifying the statehood of the state of citizen of St. Vincent and the Grenadines. No. You know, if there was any uncertainty, any need for clarity, I would have thought that maybe you would clarify what of your own volition means. And the reason I'm saying that is there are many people in this country who still talk about, for example, Camilo Gonzalez and Camilo's dual citizen. Now, up to today, I was at a bar, and big up Yellow at Pirates. Is it Pirates Cove or Pirates Pub? What you know the place this in town, opposite the gas station. Myself and two other colleagues were there, and we were discussing that. If there's anything that, in my view, needs clarity, is whether or not someone born of Vincentian parents in another country, so for example, in the US. I have children born in the US. Vincentian parents. Both parents are Vincentian, but they're born in the US. That child is entitled to an American passport as an American. Are you going to tell me that that child cannot run in St. Vincent and the Grenadines because they are dual citizens and they have a foreign passport? Clarify that. Would that be considered? Would my daughters, my children be considered performing an act of their own volition because they have an American passport? Clarify that. Put that in the Constitution once and for all, so we know. A friend of mine said to me, Sehon, let me show you how unfair this thing is. By the way, I was supposed to say earlier, Clark, I'm walking through town the other day, and I'm hearing behind me, I swear to you, I'm hearing behind me, Sehon King, Sehon King. So me not look wrong because I'm thinking, okay, King is not my surname, so. I eventually looked around and there's a lady behind me and she's smiling and saying, she said, you notice I say Larry King, you know? I say Sehon King, you know, so my name is changed. I'm no longer the fake Larry King, I'm the real Sehon King. But you know what, I appreciate, you know, those warm moments from those individuals who follow the program. My friend said to me, Sehon, there were 3 good friends, myself and 2 others. He said, after school, at different points, we all migrated. I came to the US, my friend is talking to me. One of my friends went to England, one of my friends went to Canada. All of us acquired citizenship from the country of our choice that we moved to. He said, it is unfair to me that those 2 can go back home without giving up their citizenship and become prime minister. But if I want to, I have to give up my passport, my citizenship, give up my 401k and this and that and so on to come and serve the country. And my friend said, and the truth is, I contribute more to the development of St. Vincent and the Grenadines than both of my friends combined because, and I know that. My friend is involved in all the groups in the States, contributing significantly money, time, and so forth to St. Vincent and the Grenadines. But the NDP says, I don't value your contribution because you live in the States and the American passport. But those individuals who don't contribute, who ain't involved in the group, who don't do nothing, who probably had to come home to St. Vincent and the Grenadines, they can pick up any time at all and come home and become Prime Minister. And that's the unfairness of the thing. And so that same friend of mine, who by the way supports the NDP, was saying exactly what Jomo said. Why not make it open? If you really want to do something, you say, listen, we're going to make this thing open. We're going to amend the thing so that every Vincentian citizen, once they're born in St. Vincent and the Grenadines, no matter how, if they acquire citizenship to another country, they can still run. But you narrow it down to just Canada and the Commonwealth because you want to protect, you want to serve yourself, you want to make sure that Bramble and Friday can hold on to power. That's the self-serving, unwise nature of this amendment. I don't care what anybody tell me. And I hear some people talking some nonsense and comparing different things. And I realize, boy, since the elections, a lot of people start to come out of the woodwork. A lot of people start to come out of the woodwork. And you wonder, mother of boy, they missed the education revolution completely. Because, like, they not think. They're not thinking. That is where we are. I believe, like Jomo, that the amendments are self-serving, they're unwise, but they show the true nature of the NDP administration. You have new wines, but the new wines have been poured in the same old self-serving NDP bottle. The new wines have been poured into the same old self-serving, self-interest-seeking bottle of the NDP. And so you can't expect nothing better from them. And it's up to us now, as a people, whether or not we're going to sit down and accept what they're giving us, or we're going to say, listen, nah, we can't accept that. Look, the truth is, from a parliamentary standpoint, there is absolutely nothing preventing the passage of that bill next week. Nothing. All 14 members would say aye. And one, well, I believe it's not constitutional, so I believe senators could vote as well. So all 18 would say aye. And the three of, is a 6-1 majority, you know? There were a ratio of 6-1, you know. Oh, they have 6 members. Listen, 6 members could speak from the NDP before a single member of the ULP speaks. That's the majority that they enjoy. So there's nothing stopping them from passing that. And so by next week, Tuesday, we could have a brand new law in the country. One that simply protects the interests of Godwin Friday and Fitz Bramble. One that reinforces the reality that Godwin Friday holds his Canadian passport proudly in his front pocket and his Vincentian passport in his back pocket. One that tells you that our Prime Minister, the leader of our country, is not satisfied with our passport and does not feel sufficiently proud about St. Vincent and the Grenadines and its symbols, its national symbols, the passport being one of them, to be able to renounce any other. It's like a marriage. It does say forsaking all others. He will not forsake his Canadian citizenship. This is not as a discussion in the bar today. This is not a regular, ordinary man who looking to make a way and looking for opportunities, so he need the Canadian passport and citizenship. This is the leader of our country. This is the leader of our government. This is the head of our government. And he's telling you, I will not commit to St. Vincent and the Grenadines alone. I rather trample on the constitution of this country to protect that Canadian passport. If you ask me, give up the passport or mash up the constitution, I go mash up the constitution. If you tell me, give up the passport or create social unrest in this country, he will create social unrest. That's how much his passport means to him. That's how much. There's no principle here. Because had it been a principle of dual citizenship, it would have been broadened. And it would not have been done before the hearing of the live court case. This is about self-preservation. And that's why I believe that somebody convinced them. Somebody said to them that, boss, there is not going to be any by-election. They will just put Luke and Carlos in the seat because you were not validly nominated. And so they're trying to put the guardrails, to use Jomo's words, the insurance policy, the security to hold on to the power. And you know something? There was something about me that was saying, boy, you know, I feel if it's anything, they might call a general election so that everybody could go back to the polls. I don't want a general election. Let's him clearly become Prime Minister. Get it Friday. With a level of pomp and arrogance, he and Bramble, because you all knew. And like I said when Jomo was on, you were told before the elections, anyhow you get nominated, we are going to challenge your nomination and your election because you're a dual citizen. They had time to renounce the thing. The people who voted knew that if they voted for Fitzbramble and for Godwin Friday, that their vote was going to be challenged and invalidated because those guys had dual citizenship. They knew. So the electors knew, Fitzbramble knew, Godwin Friday knew. And they chose to ignore all of that and engage in something that was unconstitutional, putting themselves up to be nominated, knowing that they were not eligible for nomination. And so now we can't vex because you were told before you went into the elections. You were warned. And that's why I told you, you can't compare 2015 and now. It's two different things. It's two completely different things. Two completely different things. So it's interesting to see how this will play out. It's interesting to see how it will play out. And I plan to be in the court. But we warned you. And I said this yesterday. And I'm not saying this in any kind of malicious way. But many of our brothers and sisters of Labour who thought that they were going to give the NDP a chance, innocently, well, you know, we had welfare and Labour for 25 years. Let me try somebody else now. There's a change. Let me try something else. If it don't work out, you could always. This is the result of your innocent act of giving somebody else a chance. And you must be at home going, hello, this wasn't what I intended. This wasn't what I voted for. I wanted to see if they would bring some freshness, some newness to the country, some innovation to the country. And they haven't. Instead, they choose to be self-serving, to create laws just to benefit themselves. And I'll tell you something, and I'll end with this. That is how the dictator scope creep does start. That's how it plays out. That is the way the dictator scope creep plays out. It starts small. A little here, limiting this, limiting the press, limiting, and before you know it, it expands, and people's rights and freedoms are infringed and narrowed. So we start with an innocent little law. Oh, let me try and clear up the ambiguity as to what a foreign power is, and let me put in the law that Canada isn't a foreign power or state. The intention of which is just to make sure that Godwin Friday and Fitzbramble and Louise Mitchell. Because I remember Louise Mitchell is Canadian, because I remember that story of the Canadian. Now, I don't know whether she's Canadian by birth, by descent, or by naturalization. I don't know. But I know she's Canadian. And so you have the dictatorial scope creep. First, you have the little inch. Let me make Canada a part of St. Vincent so that Godwin Friday and Fitzgerald Bramble. By law, they're making Canada a part of St. Vincent. What next? Well, you know, I find 5 years is too short for us to complete what we really want to do. So let me extend the life of the term from 5 years to 7 years or 8 years. People did that. People did that. They could learn from Kishore Shallow, Dr. Kishore Shallow, the Minister of Tourism. A term of office for CWI was 2 years. Kishore Shallow decide 2 years doesn't give you enough time to do what you want to do. So we expand that to 3 years. So now a term of office is 3 years. So Kishore should be spending 4 years as president. Instead, he will spend 6. Essentially spending 3 terms. But he amended the constitution to do that. So don't put it past the NDP to follow the Kishore blueprint. And so a term in office is 5 years. But listen, we are supermajority. We tell them give me 60 days, then 100 days, then 1 year. And after 5 years, nothing to do. Let me extend it so we could say in the first term we did XYZ. Let me extend the term to 7 years or 8 years. And for people who want to hold on to power, that wouldn't be enough. That wouldn't be enough. So you know what? Let me get this inconvenient thing called election altogether. Let me ban elections. Let me change the law. No elections required. Let me just stay for as long as you want to. It might sound far-fetched, you know. But when you see these signs of dictatorship and authoritarianism, where people think that their role is to interpret the laws, not just pass it, but also to interpret it. And so they are going to give whatever interpretation benefits and suits their circumstances. You know, we're heading down a slippery slope. You know, we're heading down a slippery slope. We have to raise our collective voices, as Jomo said. And when I was talking to Jomo earlier today, there was someone else there as well, and the person was saying, the government needs not think that the silence of people who are centrists and so forth means support. They'd be wrong to think it. They're ardent supporters. They're cheerleaders. Oh, it's a masterstroke. It's a masterstroke. But if you listen only to your echo chamber, you start out wrong. You start out wrong. This is a masterstroke. It's an act of cowardice. It's an act of self-serving, self-interest. And it's an act that I believe threatens our very democracy, since the government feel that they can do what they want with our laws, shaping the interpretation to suit them. That's not how it should work. That's not how it should work. And I know they ain't going to reconsider nothing, because you heard Jamali and you hear them going out. They pump us. The wall is there. It's 14-1. So we could do what we want because we are 14-1. We have to voice our opposition to this, loud and clear. And if, whatever it takes, in a peaceful, coordinated manner, make sure our leaders know that we do not support such a trampling of our Constitution for the political self-interest of a narrow few, specifically Godwin Friday and Fitzbramble. If you want to make real, genuine amendments, wait till the court case done. And when it's done, you can make laws, amend laws, or whatever to specifically address that matter going forward. Not trying to circumvent the process now and making something retroactive. We see what you're doing. Trust me, we ain't dotish. And with that, let me thank all those of you who stayed with us for the entire period. We've been on for about an hour and 40 minutes. And many of you, most of you, have stayed put. So I want to thank you so much for that. Let me thank Jomo Thomas for being a part of tonight's program. I really enjoyed that discussion. And based on the comments that I'm seeing here, many of you enjoyed it too. Thank you again for all of your support. Please like, please share, please subscribe. Let's go this thing now. I want to hit 2,000 by Carnival. I want to hit 2,000 by Carnival. And I believe we can do that. So please, like, share, subscribe. Let's push this program out. Let's cause it to continue to grow so that we can educate, inform those out there with enlightening discussions that are relevant to St. Vincent and the Grenadines, to the region, and to the world. Until next Thursday, when I am back with you with another edition of Up Late with Sehon Marshall, let me bid you a good night.